open. You may be seated.
Good morning, Mr.
Thank you.
Mr. Weisberg?
May it please the Court, Michael Reisberg for the appellees whose application was granted and the defendants in this case. Because this is an impounded case, I'm going to make every effort not to refer to the named parties. I represent the home. There's also an individual defendant who's alleged to be a counselor. I'll refer to him simply as the individual defendant or the defendant, my client as the home. As this Court knows, the case arises out of the plaintiff Jane Doe's allegations that she was sexually abused by her one-on-one counselor, the individual defendant, while living at a residential group home for young women operated by my client. The issue before the Court is the accrual of Doe's cause of action for statute of limitations purposes. And just to put that into some context, Doe filed her complaint on January 23rd of 1997, so her claims will be time-barred if they accrued by January 23rd of 1994. And that, in fact, was the finding made by the trial court in this case, which dismissed all of Doe's claims under the discovery rule because she knew or reasonably should have known that she was harmed by the fall of 1993. And I was not going to go through a chronology of all the facts in this case. It's fairly fact-intensive, but I think it's important to point out that all of the alleged sexual misconduct in this case occurred in May and June of 1993, about 6 months before the statute of limitations date, and Doe was 18 years old. She was the age of majority at the time of that alleged abuse. So this is not a case of sexual abuse against a minor. It's essentially one of alleged sexual abuse by a de facto counselor, if you will. I would like to begin by addressing the purely legal argument, which was the tolling doctrine applied by the appeals court. As the court, I'm sure, is aware, the appeals court divided Doe's claims into fiduciary and non-fiduciary claims and affirmed the grant of summary judgment with respect to all of the non-fiduciary claims. But with respect to these purported fiduciary claims, the court held that they were not time-barred, and in doing so, the court held that those claims were not subject to the discovery rule, but instead were subject to an actual knowledge standard which derives from the breach of fiduciary duty doctrine.
Actual knowledge of what?
Actual knowledge of breach of fiduciary duty, which is...
But is it actual knowledge of the cause of action or actual knowledge of the facts that give rise to the cause of action?
As I understand the appeals court's decision, and it's actual knowledge that a fiduciary duty has been breached, which is very different than the subjective prong of the discovery rule, which this court has clearly held in past cases such as Bowen v. Eli Lilly, that the plaintiff does not need to have knowledge of breach of a legal duty for the statute of limitations to run.
Mr. Weisberg, could I interrupt you to ask you this? It seems to me that the actual knowledge rule in a fiduciary context has often occurred, for example, when there's an economic relationship, for example, so the fiduciary is stealing from the beneficiary. And I think courts have been hesitant in those circumstances to impose a new or should have known, because the very nature of a fiduciary relationship is that you trust the fiduciary. You don't have to go and ask for bank statements and to monitor the fiduciary. And that's why I think Justice Spina's question really has import, because presumably in those cases, if the beneficiary knew that money was missing, she might not have known, or he might not have known, that the fiduciary was stolen, had stolen it. If we adopt a new or should have known rule, in other words, not an actual knowledge in these circumstances, does that leave beneficiaries in a very vulnerable situation in things other than where they have been personally injured, as she was here?
No, I don't think so at all. And I wouldn't suggest, this Court has long recognized an actual knowledge standard in certain limited circumstances where there is evidence of fraudulent concealment, or there's a formal trust relationship that warrants application of this repudiation of trust doctrine.
Right.
What the appeals court did in this case is greatly expand this actual knowledge standard beyond those very limited parameters. And the court has essentially said that now in all breach of fiduciary duty cases, the discovery rule no longer applies. And it has. It's always applied. It's always applied in addition to the actual knowledge standard when these other limited circumstances warrant it. But now the appeals court's holding is so broad sweeping as to say we're no longer going to apply the discovery rule ever in breach of fiduciary duty cases. And now the only standard that is going to apply is this actual knowledge standard, which is extremely deferential to the plaintiff. It's very forgiving, and it's justified in those limited circumstances where the courts have applied it, because I think that the beneficiary is entitled to have an expectation that he or she is relying on the fiduciary to act in their benefit, so that even if the beneficiary is aware that maybe they're being harmed, the courts don't want the beneficiary to have to second guess the fiduciary.
I'm sorry, go ahead.
Well, how do you reconcile the Demoulas and Latika cases, given your position?
I think that both Latika and Demoulas were cases that involved those traditional limited circumstances in which the courts of the Commonwealth have always applied the actual knowledge standard.
Would you be advocating one standard for economic or financial fiduciary relationships, legal perhaps too, and another for personal relationships?
No, I'm not making that argument. I can imagine there could be circumstances the fiduciary duty theory has been applied to professionals like attorneys and professionals like counselors who have a fiduciary duty to act in the best interests of their patients. And if there were circumstances in which the facts warranted application of a fraudulent concealment doctrine in a psycho-patient therapist-patient relationship, I could imagine that the fraudulent concealment and actual knowledge standard could apply. And in fact, I think in Riley v. Presnell, where the court refused to apply the actual knowledge standard in that case.
Let me ask you this, and I'm going to ask Mr. Fallon as well, so he has due notice. What the appeals court said was the limitations begins when the beneficiary actually learns that the fiduciary has breached the trust, and then later on says that the counselor was not just causing the victim psychological harm. It wasn't just knowledge of that, which the appeals court seems to think is barred by the statute of limitations, but was by his acts breaching the fiduciary obligations he had assumed. What is your understanding in the facts of this case as to what that distinction is?
I am not crystal clear on exactly what type of knowledge would have satisfied the appeals court under this standard. And just to demonstrate how misapplied I think this doctrine was in this case, that when the actual knowledge standard is applied where it always has been in a formal trust relationship, the rule is that the beneficiary is entitled to rely on the fiduciary even if she knows she's been harmed until the fiduciary actually says, don't count on me anymore. I'm not acting as your fiduciary. You can't count on me. So, start second guessing me. If we were to apply that doctrine literally to this case, then that would have occurred when the counseling relationship ended.
But what's so different about this case than the Latuka case and the Demoulas case? Is it because the underlying facts occurred right under the nose, right in front of?
Well, to the beneficiary.
Right, they occurred to the beneficiary directly, whereas in Latuka and Demoulas, there was the management of money that was being conducted out of sight of the beneficiary.
Those cases were a very good example of circumstances in which, while arguably the beneficiaries maybe knew they were being harmed, they were entitled to continue to rely on people that were maintaining a fiduciary relationship, and the court didn't want to, penalize them for that or require them to second-guess the fiduciary.
Mr. Weisberg, is it possible that what the appeals court was saying, and if it is, what is your response to it, that she didn't know, she knew what was happening to her by this man, this older man. What she didn't know was that he had any fiduciary duty to her. I mean, and so that she had to learn that there were special reasons why what was happening to her offended the law. And it was once she learned that the statute of limitations. So unlike a trust instrument where you know you're the beneficiary, right? The trust says, here's the fiduciary, you're the beneficiary. The appeals court seems to be saying she didn't know.
I don't think the actual knowledge standard has ever required the beneficiary to understand the formal underpinnings or workings of what it means to be a fiduciary. I think
wouldn't that require a very sophisticated plaintiff to be, in order to be put on inquiry that they've been harmed, to have to know that, I mean, to know that it's a fiduciary relationship is a sophisticated concept.
It is, and it would be an extremely forgiving tolling doctrine to plaintiffs. I can't imagine circumstances in which the statute of limitations would ever run. I'm still working to understand how fiduciary law works. So, I mean, it really greatly undermines the effort that this Court has taken to craft the parameters of the discovery rule. And what the appeals court's decision has done essentially is created a double standard, so that now in almost any sexual abuse case in which there's also a derivative claim for breach of fiduciary duty, the plaintiff can try to avail themselves of two different tolling doctrines. Well, if my non-fiduciary claims are time-barred under the discovery rule, I can always argue that these same facts under a breach of fiduciary theory are not time-barred under this actual knowledge standard. So that's how this precedent is going to change the statute of limitations as it works in sexual abuse cases, and it's going to have an even broader effect and change on all of breach of fiduciary duty cases beyond that small minority that involves sexual abuse.
I take it that, as I understand the facts, the counseling relationship ended in June of 1993 or thereabouts?
That's correct.
And in fact, at that time, didn't the defendant in this case, the counselor, specifically tell the victim that she shouldn't tell anybody about the relationship or otherwise he would be in trouble?
That's right.
And then he got fired when the school sort of suspected that this fellow was engaged in inappropriate relationship.
Correct. And that goes to our argument that assuming the discovery rule is going to apply, and I would like to, with my very few remaining moments, just address that as quickly as I can. I think the trial court was correct in finding that Doe possessed the requisite knowledge before the end of 1993. She knew from the very outset of this relationship that it was wrong because the defendant was her counselor. The fact that she also knew it was wrong and immoral because he was married doesn't detract from the fact that she knew it was wrong because he was her counselor.
Mr. Weisberg, to what extent has there been a claim that the insistence of the counselor that he continue a relationship with her, in other words, if one sees it in sort of classic influence or power terms, that he should be precluded from asking her to recognize the harm while he was still attempting to exert enormous influence over her?
And those cases are not uncommon, but that is not our case. And you've seen court cases.
Tell me why. I mean, he continued his contact with her. I mean, the counseling relationship ended, but his relationship with her didn't end. I mean, he pursued her.
Well, I think that goes to the reasonableness of her lack of knowledge, and under this court's holding in Doe v. Crichton, I think for the same reason that plaintiff couldn't demonstrate that she would satisfy the objective prong, neither can Doe in this case.
What's the best argument for that? I mean, this is a very fragile person, very fragile, and after the counseling relationship ends, I mean, why isn't that a fact that should go to the jury? That's not the fiduciary claim. That's a related claim.
She lacks the necessary expert opinion that the plaintiff in Creighton, as the plaintiff in Creighton lacked it. The timing between the abusive conduct and her.
What's the last date of his attempt to contact her?
He attempts to contact her in August of 1994, but in the fall of 1993, he had tried to contact her one time before that, and at that time she said, I know this relationship has been harmful to me, it's been emotionally detrimental, I know it's the reason I ended up in the hospital, I ended up trying to take my life, I don't want to see you anymore, if I ever thought I was in love with you, I'm not in love with you now.
So he contacts her again, she decides she's ended the relationship, and he contacts her again. Why doesn't that extend the statute of limitations? Because...
Well, that initial contact didn't create additional facts that give rise to her cause of action. So the only inquiry would be whether that additional contact somehow changed her state of mind and her understanding as to the facts that occurred back in the spring of 1993. And there's no evidence in this case that anything about his attempting to contact her then changed her understanding. The plaintiffs rely on her testimony that she didn't realize until then she'd been manipulated, but there's no support for their view that knowledge of manipulation is the relevant criterion. Instead, it's very clearly knowledge that you have been harmed by the defendant's conduct, which you know to be wrongful, and I submit that occurred in the fall of 1993.
Thank you, Mr. Leisberg.
Thank you.
Mr. Fallon?
Good morning, Your Honors. Richard Fallon for the plaintiff here. Your Honor, I also agree that the psychotherapist situation should be treated differently from the financial situation, but in fact more favorably to plaintiff.
Mr. Fallon, I have a question for you. What public policy would underlie abandoning the normal rule that the question is when the plaintiff knew something was wrong sufficiently enough to start some inquiry?
Your Honor, I'm not asking you to abandon anything. I'm asking you to affirm and continue the Riley versus Presnell rule. And in fact, I think the key part of Riley versus Presnell that I was reading is that it's a long time ago, but it turned out in Riley versus Presnell, the plaintiff went to a second psychotherapist who told him that was terribly inappropriate treatment. But then later on, that second therapist filed an affidavit saying, I did not tell him as a result of the bad treatment that he was harmed. And that was the whole key point in Presnell. And Palermo, knowing when you are harmed by the counseling treatment.
Is the Riley case incompatible with the Latuca and Demoulas cases?
Don't think it's incompatible, and I'll tell you why. Because I think we have much stronger than Riley, because in his case, the second therapist shortly thereafter told him that was terrible treatment, that was highly inappropriate. In this case, we don't have that. We do have the plaintiff saying, yes, I knew it was wrong because he was married and a counselor. But that's, and defendants here are saying, well, that means are at least implying that means she knew that the counseling treatment was inappropriate.
If Riley had been decided after Demoulas and Latuca, would it have come out the same way?
I don't know, but my argument here is on Riley as it is, which the appeals court didn't even get to. And I guess I'm arguing to you, you don't even have to get to the issue the appeals court get.
What do you mean?
Well, under Riley versus Presnell, the motion judge's decision should be overturned.
On all, you mean on both with respect to fiduciary and not...
Well, this has been limited to fiduciary. So, but on the fiduciary as a psychotherapist, indeed. And one fact I think is very important is, rather than using that, I'll call her Ms. N, the licensed social worker who was working with the school. She called his actions, the individual defendant's actions here, clinically inappropriate. And so not only did he was a supervisor at the home, and God forbid when you read his letter about AIDS, et cetera, accusing her that he was the home supervisor. But in any case, she called his actions clinically inappropriate. That surely implies psychotherapy. And of course, he used the exact words of psychotherapy. You have to tell me your innermost secrets, your sexual...
So what you're suggesting is that someone needed to tell her that not only was this inappropriate and harmful to her, which she knew, but was clinically inappropriate. Is that the magic piece of knowledge?
Well, the way I put it, that his counseling relationship, in fact, we could say 3 different incidents this is one of the issues with the trial judge said, well, she knew his conduct was harmful. Well, indeed, when she tried to commit suicide in June of 1993, she thought what was harmful was that she couldn't see him anymore. In other words, he was her savior. He was her salvation. It was 180 degrees from this claim. That's not this claim here.
I take it that, stated differently, what you were saying is she knew that the act, she knew it was, quote, wrong. He was married.
Right.
She knew that it made her feel bad, but she didn't know, is your position, that this conduct directed to her would psychologically injure her or injure her in some respect.
Okay. She thought when she tried to commit suicide, she thought that was the greatest thing that ever could happen to her. She thought he was her salvation.
Well, following that up, if that's your argument, what if, as the motion judge asked, what if the relationship lasted 20 years and then goes sour? Can the plaintiff go back and claim harm and say that the statute was told?
Here's where the motion, it's not the relationship. That's where the motion judge, as you remember, the motion judge wrote, well, she should have known that a relationship with a married man of superior years than herself would have led to, problems. And I don't think the motion judge was using the old canard that, any woman is a predator. I don't think that's at all what the motion judge meant.
But surely she should have known, should she not, that if one is in any kind of supervisory, in the broader sense, relationship, teacher, priest, employer, counselor, manager of the home, that these are relationships which are predatory relationships and are likely to cause harm.
Well, I think that's what she exactly meant when she said she thought it was wrong. But the key thing here is that it was a psychotherapy relationship. And the key thing about that...
Well, he was not a psychotherapist.
Well,
he wasn't a therapist at all. He was a counselor who happened to be assigned to this house.
Yeah, that's why I say two things. Well, that's why I say it's so important that Mrs. N, who was the so-called clinically appropriate, he was acting as a psychotherapist.
Well, why should that counseling relationship have anything more to do with the whole analysis than as one factor in the equation of when it's reasonable for the plaintiff to have been put on inquiry that she might have been harmed? Why shouldn't that just be a factor that we consider?
Because, there is the key, and Palermo talks about that specifically, but also Riley versus Prinsonell talk about it, because it talks about if an initially reasonable person would, by the experience formed, have his or her judgment altered in some way. That's classically the psychotherapy relationship, because it's the, as they call, transfers, but it's really the idealized parent that the later treatment person calls.
Mr. Fallon, Riley didn't turn on the existence of a fiduciary relationship, correct?
Well, it basically said it's the same. It does have fiduciary aspects to it.
Right,
and then
okay.
it said, but the discovery, it's the discovery rule.
Well, let me ask you this, the question that I said I was going to ask. As you know, at 2 points, at least at 2 points in the appeals court's decision, Justice McHugh draws a distinction between the knowledge that was not just causing her psychological harm. In fact,
Right,
Justice McHugh's
right.
opinion seems to rest on the fact
Right.
that he says, that's out, the knowledge that it caused her psychological harm, but by his act, she had to know that his acts were breaching the fiduciary obligations he had assumed. That's at page 348. If the question is not whether it was causing her psychological harm, but this other kind of harm, what's the difference in the facts of this case?
No, the way I would read that, Your Honor, and forgive me, is that she doesn't have to know that it was quote-unquote fiduciary, but she had to know the harm, just as in Riley versus Presnell. She had to know that the harm came from the counseling, the psychotherapy
But he
relationship.
keeps saying, no, it's when it came home to her, using the classic
Yeah.
case, that he had breached his fiduciary duty to her. In other words, it seemed to me the appeals court was trying to draw a very stark line because it affirmed the trial court's decision that the statute of limitations, as I understood it, applied to her knowing of the psychological harm. And what we have up here is not that, we have the breach of fiduciary duty.
I think the problem here, the Gordian knot here, is there are three different types of psychological harm.
Now, wait a minute. Let me just read it. This is the
Okay.
appeals court. As noted, she, your client, the victim, clearly knew contemporaneously of the sexualized nature of the relationship, that she clearly knew it was wrong, that she knew with her married counselor, and knew well before the cutoff date that the relationship was causing her psychological harm.
The relationship with the individual defendant, the sexual relationship.
Was causing her psychological harm.
Exactly. And let me get to what I was just saying.
No, but if
The
that's
three different kinds of harm.
If she knew that well before in the appeals court's language, what else is she to know that extends the cutoff?
As they said in Riley, that the counseling relationship, which is indeed the fiduciary relationship, and that's one of my...
That the counseling relationship what?
That the counseling relationship caused her harm. In other words, first, she felt first in June that being deprived of his relationship and was causing her harm. That's why she tried to commit suicide. In other words, as far as I can tell, defendant is saying she should have known when she thought she was deprived of his relationship that it was the greatest thing, the relationship. She should have known that it was harm. Then the second...
So if she had gone to a dentist, it would have been a different case.
Exactly. Gone to a doctor. Harper versus Weinstein is the appeals court case where they say no mental health was involved, and I think they're right on that.
So what are the three different forms of the harm?
Thank you, Your Honor. Okay, first, she thought because she was being deprived of him, that the group home said, defendant, Mr. F., you can't see her anymore. She thought that was the great harm. In other words, she tried to commit suicide because she wasn't going to see him anymore. Not because she thought his counseling was bad, but because she thought...
So you say one is the counseling relationship?
No. The first one is that she was being deprived of his personal relationship. The second one, and this is where the judge got it wrong, in other words, she thought being deprived of him was emotional harm. That's the first injury. The second injury is the breakup of the relationship, and that's where the judge got it wrong. And that's, to go back when I said married man. In other words, the judge saying, well, she should have known that their sort of emotional relationship, as a personal relationship, would have ended because he was a married man.
But she knew that this particular conduct that was caused by this particular man was causing her harm. Isn't that enough to put her on notice?
You have to separate conduct. Perfect. Let me go back with my analogy in my brief because it's a perfect one. It's a very good one here. Let's say you have a surgeon and he does an operation in the stomach and he tells us, well, you're going to have a sore tummy because I'm going to have to lean on your chest. And the patient does have a sore tummy for a good long time. And then later on finds out, well, he left a sponge in there. Well, she knew way back when that the conduct of that surgeon caused her harm, but she didn't know the nature of the conduct, and that was legally wrongful. Well, here, Ms. Doe knew, or at least felt first, that being deprived of him caused her harm. Second, the breakup, but that's not this claim. This claim is not about being deprived. We're not claiming, oh, he should have stayed with her. We're not claiming the emotional breakup, and that's the end of June. We're claiming when she realized that his counseling, that his needs as a counselor, and I argue that it could be inferred that July 94, when she first was able to tell somebody else, she told her boyfriend, and that's the first time.
Well, it strikes me that there's a big difference between the example you just used, and I understand it often comes up where the clinician is basically telling the patient that this is all clinically appropriate, and therefore the patient, trusting that this is clinically appropriate, engages in stuff that she later realizes is unbelievably wrong. But that's not what's going on here. I mean, the counselor told her, don't tell anybody about this because I will get fired. I mean, isn't that different?
But she was extremely emotionally vulnerable, and that's where the language about a person being experienced. The motion judge said it was unrelated to the complaint of conduct, but her past was quite related to the complaint of conduct. And that's where the question isn't that she knew it was wrong. She knew it was wrong but thought it was the best thing for her. The question is, when did she know, and that's the Riley and Palermo cases, when did she know that the counseling activities caused her harm? In other words, the harm that when is the counseling, not the fact of she couldn't see him anymore. That's when she tried to commit suicide. That's not the claim that he should have kept seeing her. The claim is not he shouldn't have broke up with her. Sure, when she broke up, there was all that she felt to her. But it's when she was able to finally tell somebody else and finally realizing that there was wrongful counseling, that this experience as a psychotherapist was, you say clinical, but that she was being harmed by that. You have to know what you're harmed by. Just like the sponge analogy. You have to know what you're harmed by. You have to know the cause of
Well,
action.
she knew the sexual relationship with a married person was not good, right?
Yes, Your Honor, morally, exactly. She knew it was...
Well, but what you're saying is, if she had had a sexual relationship with the married maintenance man...
Yes. Or just a married supervisor. I'm sorry, I
Well,
didn't...
I'm trying to find somebody who's got no authority over
Yeah.
her. He's a maintenance man. He's the janitor. He's the gardener. He's the, the cleaner. You would say, yes, that may fall into what you've described as the first and the second, right? The first,
Right, exactly.
one of the two, but not the third, because she somehow didn't know that it was because he was her counselor.
And that footnote in Palermo, I think, is important.
How do you respond to the defendant's statement that you need an expert opinion to say the counseling relationship itself is what causes the harm?
Well, I think we have the later affidavit by the treatment therapist later on. I think it's page, forget what page of the appendix. And she talks about he was the idealized parent. And that's the classic transference. I mean, even though she doesn't use the magic words transference, you can read Simmons and all the other cases. That's the classic transference situation. Thank you, Your Honor.
Thank you, Mr. Fallon.